Hello everyone, I'm attorney Catherine Henry. I've had a lot of calls and emails and Facebook tags and questions, text messages. People are wondering about this one-page document that they've seen. A letter, it says letter to prosecuting attorneys, and it has my name at the bottom. We need to clear the air on what this is and where it came from, and what somebody's doing to confuse the work that I've done. So the document that many of you have been asking me about is not a one-page document. It is an 11-page document. Someone decided to take a screenshot of the very first page and start sharing it and telling people that it's a court order. Clearly does not say it's a court order. Doesn't say anywhere on there that the court authored this. It doesn't say the word order at all. It says that it's a letter to the prosecuting attorneys and city attorneys in Michigan. That's exactly what it is. It's also disingenuous for someone to take an 11-page document that I wrote, do a screenshot of the very first page only, and then share it to everyone claiming that that is the document. No, that's essentially the cover page. There is a caption. There is an indication of which attorneys drafted it. This was going out primarily to the prosecuting attorneys and city attorneys in the state of Michigan. So I had actually 3 other attorneys suggest to me that although I started in original letter format, which made it only 6 pages, they suggested I go ahead and put it in a more legal format, so it's in the format that an attorney would typically read through a legal analysis. Okay? So what this is it is a letter to all prosecuting attorneys and city attorneys in the state of Michigan talking about enforcement of these executive orders, but it is in the format of a legal brief. This is literally copied and pasted format of the last brief that I filed in the Michigan Supreme Court. It is not itself a document I have filed with a court. It is following that format because the audience, the main audience of this letter was going to attorneys, and other attorneys suggested that it would be more well received and understood for what it is if it follows a proper legal format of any other legal analysis that we would look at, essentially a brief. So it has the front page, the one that everybody is sharing, just not everybody, that some are sharing just the screenshot of the first page. It then has a table of contents. It then has an index of authorities. It lists every single executive order I'm referencing, all of the statutes involved, all of the constitutional provisions involved. It then lists all of the cases that are involved here. And then, as you do in a Michigan Supreme Court brief, you are addressing the questions involved. Now, this is not something that I was bringing to the court, so it was not following the format of an appellant brief. It is following the format of an amicus brief because I explain later on down here that the other attorney and I were submitting this letter as an amicus, as a friend of the court. So we identified what questions that we are attempting to answer, and then how the Attorney General sees that answer and how we see that answer. Then we explain who we are and why we are writing this, and why it's our duty to write this. Then we explain the whole legal analysis, all the points that have been raised in the media and with attorneys and legislators and the governor's office and the Attorney General, Dana Nessel. Go into all of that. So, if you know that you've gone to my Facebook page or you've gone to my website and you've pulled off the 11-page document, because I shared the whole thing as one document, if you have taken the 11-page document I shared and screenshotted only the first page which does not contain any of this other information at all, which is the main information. This is a summary. It's not even a summary. This is the title page. If you are sharing just the title page, knowing full well that there is an entire document behind it, yeah, you're going to be the one that's having some problems because you're being extremely disingenuous and sharing misinformation, because at that point, it is a little bit more likely to confuse people and make them think that it is an order of the court. Now, some of the people that have been calling me or emailing me or Facebooking me and asking me if this is an order of the court, once I explain to them, no, it's not an order of the court, you are only looking at the first page, they then seem to wonder or ask, what does that mean then? Are we waiting for a court order to say this? No, we're not. We do not get our rights from the court. We don't get our rights from Attorney General Dana Nessel. We don't get our rights from the governor, Gretchen Whitmer. We got our rights from the Almighty God, and then we cemented those rights in the U.S. and Michigan constitutions. What my letter does is points out to these very attorneys and law enforcement officers, you can't enforce something that is not only blatantly illegal on the face of the statute, it's also unconstitutional. They have a duty to uphold their oath of office. If they don't, if they go outside of the bounds of that oath, well, then they're going outside of the bounds of their governmental authority. So, am I telling you that if you're a business owner and you open your business because that is your legal right, nothing is legal after April 30th to stop you from doing that, does that guarantee that you will not get a ticket or that you will not have the police try to issue you a citation, or that you would not have the Department of Licensing and Regulatory Affairs threaten to pull your business license? No, I can't guarantee that. It's with any situation. There are cops, unfortunately, all across the country, not just our state, that issue trumped up charges, if you will, every day. There are prosecutors that prosecute people that they know are innocent. It happens. There's bad people in every single profession. Every single profession. Does that mean the entire profession is bad? No. Am I saying that all cops are bad? No. Am I saying all prosecuting attorneys or city attorneys are bad? No, absolutely not. This letter is not a threat to anyone except those who are already planning on violating the Constitution and the statutes involved. Well, if they are government officials or law enforcement or prosecuting attorneys and they're planning on violating the Constitution, they should feel threatened, because that's not okay. Their jobs should be threatened, absolutely. Their careers should be threatened. Should their lives be threatened? No. Am I advocating for anybody to go out and injure a police officer or a prosecuting attorney who's trying to enforce these blatantly illegal orders? No. You don't have a right to physically harm or even threaten to physically harm someone in those circumstances. I'm not advocating for civil disobedience. I'm advocating for civil obedience. I want everyone to follow the law as it is written. I want the cops, the prosecutors, your neighbors, the business owners, your family and friends that want to go to birthday parties or funerals. I want every one of those people to follow the law. The law says after April 30th, there are no more executive orders here in Michigan. All of those orders were based on her emergency powers, which ended by law on April 30th. The full legal analysis, of course, right here in all 11 pages, not just the first one. So why do we not have to wait to have the court sort this out? Why did I not just file this in a case against the governor or the attorney general or prosecuting attorneys? Well, there are cases being filed against those individuals. I don't need to be the one to do it. Maybe I will. I don't know. But right now, what I can tell you is that we don't get our rights from an attorney. We don't get our rights from a court. We don't get our rights from a governor or a legislature. We have them now. We don't have to wait for someone to give us permission to use the rights we already have. There's some basic things involved here, okay? And it goes into detail in here, but some basic things involved. Article 3, Section 2 of our state constitution guarantees to us that the powers of government are divided into 3 branches: the legislative, executive, and judicial. And I'm going to go into the second sentence of that in just a second. But we also need to remember that Article 4, Section 4 of the U.S. Constitution guarantees to us the same thing: a republican form of government. Well, I've seen a lot of debating on Facebook about what republican form of government is. To make it easy, I'm going to go with the standard legal definition as available in Black's Law Dictionary. A system of government in which the people hold sovereign power and elect representatives who exercise that power. Right. We hold the sovereign power. We elect people to go and act on our behalf in helping us carry about the business of life. But we have checks and balances. We have a republican form of government guaranteed to us in the U.S. Constitution and in the state constitution. And specifically, the state constitution says, again, Article 3, Section 2, no person exercising the powers of one branch, say the governor's office, shall exercise powers properly belonging to another branch, say the legislature, except as expressly provided in this Constitution. Okay, well, when a governor goes beyond what our statutes and our Constitution allow, when a governor, it doesn't matter if it's Governor Whitmer as it is now or if it's a future governor, but if a governor decides that they are going to ignore the statutes on point and say, well, I know I have the 28 days. I know that the extension beyond 28 days has to come from the legislature, and that they gave me one extension and did not give me any other extensions, but I'm going to go ahead and keep issuing orders anyway, acting like I have this authority. That is called acting under the color of law. It doesn't mean that the governor has the authority to actually do that. That means they know they don't, and they're exercising that power anyway. We do not need to wait for a court to sort this out for us to live our lives. Not at all. In fact, the Emergency Management Act itself says the governor cannot exercise emergency powers and issue emergency orders that trample on our constitutional rights. It says that right in the statute. I talk about it right in these documents. So they were making it perfectly clear, even in times of emergency, we do not get to go above and beyond and have a governor swoop in to save us and tell us how to live our lives in such a way that it stops us from assembling peacefully, stops us from worshiping freely, stops us from using our right to free speech or of the press, or to petition our government for a redress of grievances, or any other number of rights that are in there. But also, it doesn't just guarantee, the statute does not just guarantee that we get to keep our constitutional rights even in a state of emergency. It actually specifically says the governor cannot violate any provision of the U.S. or state constitution. So that means In exercising emergency powers, the governor may not exercise the powers of another branch of government. So, if you want to sit at home and wait to get permission to reopen your business, to go to a funeral, to attend a birthday party, you can do that. That's your choice. However, if you would like to exercise your rights, the law is on your side in doing so. Is it entirely without risk? No. We have a risk in almost every decision we make. It's part of being human. So you have to choose what's right for you. All I'm doing is telling you what the law says and telling you, or more specifically, telling prosecuting attorneys and law enforcement officials that if they are going to choose to enforce these executive orders, then they will be violating the statutes. They will be violating the Constitution. So you guys can share the information if you want. That's fine. I'm just asking you to share the whole message. Don't just chop it up and mischaracterize it so that people all over the state become confused. That's disingenuous. That would be fake news. Real news would be sharing all of the actual information, not just the cover sheet. And nowhere on here does it say it's an order of the court. So if you're going around telling people that this is an order of the court, you probably should stop, because that's fake news. It's not signed by a judge. There's no signature line for a judge. It says this would apply in all of the courts we have in our state, from the Supreme Court, Court of Appeals, circuit courts, district courts, any case. The whole point of this is to say it is applying to any case that we could have. And it is clearly written by the two individuals right here and says respectfully submitted on May 8th. And like I mentioned, we describe in the section called Introduction and Statement of Interest who we are and why we are writing this. And in fact, why we have a duty to write this and to share this information. So feel free to share the information, but please share it in its entirety and don't mischaracterize it to try to mislead people. I will continue answering questions the best I can. For the most part, I think I am all caught up on answering all the questions that have come via text, email, phone call, Facebook message, and I will continue to do that. But please do not share part information, and please make sure you're reading it before you are putting the ownership onto somebody else to clarify things for you. Thanks, guys.